Hello. Good afternoon, everyone. Hello.
Chris, we can hear you.
Okay. Good afternoon, everyone. Can you hear me?
Yes, we can hear you. Good afternoon.
Yes, we can hear you well.
Good afternoon, everyone.
We can all hear you.
Okay. Good afternoon, everyone. I'm glad to have you all here.
Glad to have you. Loud and clear.
This is a webinar. Okay. Sorry for that. Someone, please, can we all mute our minds? Because
Please, can you start it? Please start.
okay, please. Good afternoon, everyone, and glad to have you all here. You're all welcome. This is a webinar organized by the Nigerian Bar Association section on legal practice, family law and human rights committee on the topic parental child abduction and custody rights. But we recognize all justices of the Supreme Court and justices of the Court of Appeal, judges of the High Courts. We have Justice Alera Akeredolu, Professor. We recognize also customary Court of Appeal judges, senior advocates of Nigeria, magistrates, grand caddies, chairmen of customary courts, seniors and esteemed colleagues. You're all welcome to this great occasion. We will now welcome the chief host, the chairman, NBA Section on Legal Practice, Mrs. Boma Labi, OON, SAN, for the opening remarks. Hello. Sorry for the interruptions. Can you hear me?
Please, we can all hear you. We can proceed. Thank you.
Okay. While we wait for the opening remarks, we'll take some housekeeping rules. So please, this webinar is recorded. Also, every participant has been muted for easy communication. At the end of this section, we shall have the materials made available. So this webinar is recorded and streamed live on YouTube. Our microphones are currently muted. Feel free to use the chat box for your comments and questions while the webinar is ongoing, and questions will be answered at the end of the section by the various panelists. Thank you. Okay. So can we welcome our chairman, NBASLP-FLHR on legal practice, Mrs. Boma Labi, OON SAN, for the opening remark. Okay, so without further ado, we'll welcome the moderator as she takes over from here. Mrs. Irene Purple, the Secretary, Family Law and Human Rights Committee. Please, over to you, ma'am.
Thank you very much, Mr. Christopher. Thank you very much for holding forth. I'd like to welcome everyone here. If you can hear me, please type in the comment section. Let me know that I'm audible. If you can hear me, please type in the comment section so I can see that you can hear me. So welcome everyone to this webinar. It's a very interesting one. Like the topic has already been introduced, parental child abduction and custody rights. Right now in this country, there's a whole lot of JAPA, the JAPA syndrome is on. And of course, you know that with the JAPA syndrome, people are taking on their families, they are carrying their children, a whole lot is going on, right? So the question is, how do we manage the issues? How do we manage the issues? Today we have 4 learned and experienced panelists who will be speaking to us on this topic. Each of them will take a bite. So I am so glad to introduce to you the first speaker, the first panelist for today. Her name is Ndidi Anike Valekoma. She will be discussing the theme from the perspective of a family law expert. What is parental right abduction? How does it affect custody rights? How does it affect the child? How does it affect the family? So we'll be listening to Mrs. Ndidi Anike Valekoma, who will be discussing the theme as a family law expert. Madam, please, you have 15 minutes and you have the floor. Thank you very much. Mr. Ndidi Anike, you have the floor. You have the floor now. Thank you. Please, can we kindly unmute Mrs. Ndidi Anike? Okay, if she's not available right now, we can take the speaker who is the panelist who is available. We'll be seeking for Ms. Olaide Awobile. She'll be speaking on the perspective on what is applicable in the United Kingdom. Is Ms.
Yes, good
Ms.
afternoon,
Olaide.
everyone.
Okay, thank you very much, ma'am. You have
Yes,
15 minutes.
All right. Can everyone hear me?
Yes, we can hear you.
All right. Okay.
Thank you.
Please, could you grant me permission to share my screen? It says I cannot share my screen. All right. Can you all see my screen? Can you all see my screen? Can anyone hear me?
Yes, Ma, we can all see your screen.
All
Yes,
right. Okay. Thank you very much. Okay. So my name is Olaide Awobile. I am a practicing solicitor here in England and Wales, and I'm also a practicing solicitor here in England and Wales. I'm also a barrister and solicitor of the Supreme Court of Nigeria. My areas of law are family law and immigration law, but for the purpose of this seminar, it's going to be family law, and I'll be talking about parental child abduction and custody rights from the UK point of view. Please bear with me. I've got cold, but I'll try to make myself as clear as possible. So before we start, I'll read a short disclaimer, which is that the information I'll be sharing during this seminar does not constitute legal advice in any form, as legal advice can only be given based on individual circumstances. So the purpose of this seminar is to inform, enlighten, and educate us on the current rules under the family law. The topics I'll be sharing today is child arrangements to custody in the United Kingdom. I'll be dealing with What is a child arrangement order? Who can apply for child arrangement? What is parental responsibility? What is the position of law with respect to child arrangement orders? Variation of a child arrangement order, non-compliance, enforcement of child arrangement orders, duration of child arrangement orders, change of name and removal from the jurisdiction where a child arrangement order is enforced. Then also I'll be discussing child abduction, but however, it's from the UK point of view. For starters, child arrangements in Nigeria, we call it child custody, but here in United Kingdom, it's called child arrangement. So because some people might be wondering what is child arrangement, why is she calling it child arrangement? So it's the same thing, but in different jurisdictions, they call different things, different names. So in United Kingdom, child custody is child arrangement. So what is a child arrangement order or child custody? A child arrangement order is an order from the court which details the arrangement for a child, which includes where the child will live, how they will spend time with the other parents, and what types of contact can take place, whether it's direct or indirect. So in United Kingdom, we've got direct contact, that is, you'll be able to see the child face to face, meet with the child. The child will have what is called overnight contact, that is, can sleep over at your place. Then indirect contact is contact with the child by way of letters, correspondence, and gifts. That is, you would not have like a face-to-face or one-to-one with the child. You would only write the child letters sent through the other parent or through somebody, and by way of gifts. Now, each child arrangement order is decided on the circumstances of the individual and on the family and what is in the best interest of the child. For example, if the gentleman is a drug addict or he's an ex-convict and he's been to prison so many times, it will not be in the best interest of the child to have direct contact with the father. It will be best to have what is called indirect contact by way of writing letters or sending gifts to the child, because obviously the gentleman or the woman is a negative role model. Now, the child arrangement orders are governed by Section 8 of the Child Act 1989. Now, who can apply for a child arrangement order? Here in UK, you have to have what is called parental responsibility before you can apply for a child arrangement order. So if the father does not have, I'm going to have to switch off my phone. If you have any questions, please could you put it in the chat box? I will try and deal with as many questions as the organizers permit. But for now, please could you put it in the chat box? I've switched off my phone. I would not respond to any question except via this seminar. For those of you watching on YouTube, I don't know how the organizers will do that, but I believe you should be able to ask your questions. I don't know how we're going to sort that out. So back to what I was saying. So in United Kingdom, you can only apply for a child arrangement order if you have parental responsibility. The fact that you are the biological father does not mean you have parental responsibility. Sometimes some grandparents and some other people, if they apply to the court for parental responsibility, they will be able to apply for child arrangement. So where in the instance that your client or someone does not have parental responsibility, the first thing the solicitor will need to do is to first of all apply for parental responsibility before applying for a child arrangement order. Now, parental responsibility means you have legal rights and duties with regards to the children or grandchildren's upbringing. In United Kingdom, women automatically have parental responsibility. A father does not automatically have parental responsibility. For a father to have parental responsibility of a child, he has to either be married to the mother of the child, then he will acquire parental responsibility, or he's listed on the child's birth certificate, or he makes an application to the court to have parental responsibility. For those of you joining from the United Kingdom, I'm sure some of you are aware that there are some children that on the birth certificate, the father's name is not there. If the father's name is not there, it does not automatically confer him that parental responsibility. What he needs to do is to apply for parental responsibility. Once that has been granted, then his solicitors can now apply for child arrangement order. But with a woman, automatically she has that parental responsibility, which leads to the popular saying that the law tends to favor the woman more than the men. It's not really true, but it's just the way the law has been designed, that women have automatic parental responsibility. So now, what is the position of the law with respect to child arrangements or custody? The position of the law is in line with the Children's Act 1989. Now, Section 1 of the Children's Act states that the child's welfare shall be the court's paramount consideration. Hence, each child arrangement order will be decided on the circumstances of the individual family and what is in the best interest of the child. And also, the court, when making a child arrangement order, right, the court has that duty to act in the best interest of the child. And the court can make some certain orders when you make an application for child custody, or what we call child arrangements in UK. So the child arrangement order, number one, you could apply for a child arrangement order which sets out whom the child will live with. And in the past, like I said, is called custody. Say, for example, the woman and the guy, they are dragging, oh, I want the child to live with me. I want the child to live with me, blah, blah, blah. You can apply for a child arrangement order which will specify and state who the child will live with. Then a contact order, we have instances where some people, they don't really want the children to live with them, or maybe they live abroad and they just want a court order in place where they can have direct contact with the children. That is, maybe whenever they come to the UK or whenever they want to see the children, they want to be able to see the children. Or for example, if you have a very problematic other parent, for example, say the woman, she's very problematic, you were in a relationship, because the relationship did not work out and you started dating someone, she's now refusing you to have direct contact with your children, you can apply for a contact order, which will allow you to see your children. The court will set, not necessarily timetable, we call it timetable, not necessarily timetable, times you can see your children and times you can spend time with your children. Then there's another order that the court could make, which is called prohibited steps order. This is a court order which precludes others from carrying out specific tasks. This is very popular in the United Kingdom. For example, you're a woman, you put the child in school, because the father is named on the birth certificate, without you knowing, he goes to school and picks up the children and wants to run away, or he has attempted to do things like that, or he keeps making derogatory statements about you in the presence of your children, you can apply for a prohibited steps order. Then specific issue order, this is orders that deal with specific issues. For example, you're a Christian, you are married to a Muslim, and your child is finding the whole thing confusing. You want your child to go to a Muslim school, but the mother wants the child to go to a Christian school. A specific issue order would address that. For example, you have troublesome in-laws. Your mother-in-law would come, she would come and start dictating, causing confusion, like a case I did in the past. The mother-in-law, whenever she comes from Nigeria, she will bring black magic and, chant incantations on the children. To the grandmother and her husband, they were protecting the children, but to someone that was brought here, she was like, what the, why would you be bringing black magic? So for issues like that, you would use, or you would apply for what is called a specific issue order. For example, you people break up, not you, the clients break up, husband and wife, they break up. The husband moves to London, Madame lives in Manchester, I live in Manchester, by the way, do you understand? And you start dragging, the father wants the child to go to school in London, the mother wants the child to stay in Manchester. Specific issue orders will be applied to deal with such issues. Then the next slide. Now, what will the court look at when before making a decision in the best interest of the child? The first thing the court will look at is the wishes and feelings of the child concerned. Here in the United Kingdom, before the court can consider the wishes and the feelings of the child has to be age 12. But sometimes If they think the child is matured or the child clearly knows what they're saying, sometimes the court could consider the wishes and feelings of the child from like age 10, but usually it is from age 12. So sometimes, I'm sure some of you have heard of stories when a man really wants to see the children, but because the child has said, I don't want to see my father, do you understand? Because my dad used to do this, my dad used to do that, or I don't want to see my mother, I find her scary, blah, blah, blah. It's because of things like this. There's a welfare checklist which says that the court has to consider the wishes and the feelings of the child. Then also the child's physical, emotional, and educational needs. The court will also consider the child and the effects on the child in any change of circumstances, the child's sex, age, background, any harm the child has suffered or the child is likely to suffer. For example, if the child is being sexually abused by the father or being sexually abused by the mother. We've seen instances where mothers even sexually abuse their children, and there is evidence to prove that this child has suffered this risk. The court has to put that into consideration. How capable the child's parents are in relation to the question relevant if meeting the child's needs. For example, if, I started off by saying in United Kingdom, the woman most times, not most times, the woman has parental responsibility. So when the instance that the woman has mental health issues and she is not responding to help, obviously the court will need to consider her capability, because if she's having mental health issues and all support given by the local authority is not working, then the court has no option but to place the child in the best interest with the father. For example, if the woman is a drug addict and all help is not working, she's been to rehab, she's had help from the local authority, and she keeps going back to the drugs and it's affecting the children. There are instances that the children are found with drugs or, things like that. Then the court has to put that into consideration. Then also there's section 13 of the Act, which says that where a child arrangement order is enforced with respect to a child, no one can remove the child from UK without the written consent of every person that has parental responsibility for the child. I'm going to talk more about that when we're talking about child abduction. So variation of a child arrangement order, this is quite popular amongst our people. Say, for instance, you and madam, you start dragging the child, then something changed. You cannot just on your own just say, okay, I'm moving to America, do you understand? I'm just moving without the father's consent. If you need to amend a court order, you need to apply to the court for a variation. If the other party agrees and is amicable, you may get away with it. But if the other party is not agreeing, for example, you have alternate weekend contact. This weekend, the child is with you. Next weekend, the child is with you. And that arrangement is no longer working because you now work weekends. So you want to be able to see your child during the week. And the mother is not allowing it. What you need to do is to contact your solicitor and we'll make an application to amend the child arrangement order. Then non-compliance and enforcement of child arrangement order. To be honest, most women are guilty of this act. So where in an instance that the court has said, madam, the children have to see their father, right? And because she is so bitter, she's so bitter, and she's like, what the hell? I'm sorry to use that word. I'm sorry. With due respect to your worship and the members of the bench and bar. I'm so sorry about that. So if the woman is like,
hello, ma'am.
Yes.
Hello, ma'am. Sorry to interject, but you have barely 3 minutes more.
All right. Okay. So,
yes,
so where in the instance that the woman has not complied with the child arrangement order for whatever reason, then you need to apply to the court for what is called enforcement of the child arrangement order. Now, if the court feels that the woman has been very difficult or the man has been very, very difficult, the court could punish her by way of she going to prison or taking the children from her and placing her with the other parents. The duration of the child arrangement order is usually up to the age 16 or 18. 18 if there's a living element involved. Then with regards to the change of name or removal from the jurisdiction where the child arrangement order is in place, you need to make an application to the court. How many minutes do I have left? Once my time is up, you just let me know. All right. So child abduction. Now, what is child abduction? Child abduction is when you take a child under the age 18 out of the UK without the consent of those that have parental responsibility. That was why I started off with the child arrangement, so we understand the basics, what child arrangement is, what parental responsibility is. Now, if you intend to take a child outside of the UK more than 28 days, you would need the consent of everyone that has parental responsibility. Say, for example, you jackpot, like somebody said earlier on, to the UK and you got another job in Canada and you want to move to Canada and you are no longer in a relationship with the father of your child or vice versa, you would need a written consent from whoever has parental responsibility if you need to take the children out of the UK more than 28 days. So now, what are the categories of child abduction? Number one, abduction is when a child is taken or sent abroad without the appropriate consent, which is currently a criminal offense here in the UK. Another category of child abduction is wrongful retention. For example, you mislead your madam, your former madam, and say, okay, I'm going on holiday to Nigeria. I'm going for my mom's birthday. I want Junior to follow me. We'll be back in 2 weeks. She releases Junior, and only for you to get to Nigeria, you refuse to allow Junior to come back. That is wrongful retention. Then threat of abduction. So for example, this is quite common with inter-country marriages. Say for instance, you start making threats, especially this is more for the guys. You marry a South African or you marry a Kenyan or an English person, and you're like, because you know that in Nigeria, the law tends to favor the man the more, as I heard. Do you understand? Then you start making threats that I'm going to take the child to Nigeria. You are not going to see that child again, blah, blah, blah. That is threat of abduction. Then what's the difference between child abduction, kidnapping, and false imprisonment? Kidnapping is the act of taking someone without their valid consent and holding them unlawfully against their will. Now, if you look at the criminal sentencing guides, kidnapping and child abduction are quite similar, but the difference is that with kidnapping, there is a ransom for money or other gains. That is the difference between kidnapping and child abduction. Now, false imprisonment and unlawful imprisonment occurs when a person intentionally restricts another person's movement within any area of legal authority, justification, or restrained person's permission. Now, what is the position of the law? Because I have limited time, you can always read on Section 1 of the Abduction Act. It's also an either way offense.
Thank you, ma'am. Thank you. I'm enjoying it. I'm almost carried away, but you have done up to 17 minutes instead of the 15.
All right.
I guess during the question and answer time, you would have the opportunity to, hit on the other parts that you haven't talked about. But thank you so much for your presentation. In fact, I feel like a British lawyer already. I feel like I can practice family law in UK. Thank you very much.
If anyone needs these slides, I have mentioned to Nancy earlier on, I'm happy for them to have a copy of the slides for free. You can share it with anyone that needs.
Thank you. Thank you very much. We are grateful. Thank you so much for your contribution and your presentation. Indeed, we all know that from her presentation that the child arrangement, we have the contact order, prohibited steps order, specific issues order. In fact, I love that it's so detailed and different from what we have here, but I'm glad that we have other panelists who will delve into this area in Nigeria. So I think without further ado, I'll be calling on the next panelist. The next panelist is no other than Dr. Umar. Dr. Umar Alkali. Please, Dr. Umar, please, you have the floor. You have 15 minutes to give us your perspective from the bar. Thank you very much.
Thank you, Hello.
Yes, we can hear you and we can see you clearly. Thank you for joining.
Thank you. Good afternoon, and pleased to be here. And I am one of the panelists, and I have a topic to present. Allow me share my screen.
Very well, sir.
Thank you. Can you see it?
Not yet, not yet, not yet.
Okay.
Dr. Umar, are you still here?
Yes, I'm there, but I think
Okay.
I have a challenge here. Can you share it at your end?
Okay, your slides. Okay,
Yes.
let me see how we can facilitate that. In a moment, sir.
Okay.
Just a minute.
Okay.
Okay, so your slides are about to be shared. I don't know if you can just start, and then when the slides come, we could continue, so we do not take too much time. We are.
Of Nigerian laws. As a background, the presentation starts by saying that children need protective and nurturing environment. Children need to grow and strive so that they can be responsible parents in the future. And one key way of achieving that is to have children grow in a protected environment, to have children grow in a family environment. To that extent, we appreciate the fact that children are weak, children are mentally immature, children are economically dependent. So parents have a great role to play in the way children are brought up.
Dr. Omar, you can see your slides now. We can see your slides now. And anytime you want the slide change, just let us know and then we'll work with you, sir.
Okay. Okay. So as you can see from the picture, this is the picture of a smiling young girl. From all indication, it appears that she is given all the rights she's supposed to enjoy, the right to education, the right to safe environment. And one key way of achieving safe environment for a child is to have the child grow under a lawful custody. Where parents abduct a child, it will be very difficult to provide the needed protection to the child. To that extent, issues of parental child abduction has a direct linkage with the way the child will grow up, the maturity of the child, the protection of the child, the survival of the child, and the development of the child. Next slide. The next slide shows a mother with her kids. And from the background, it's very clear that she could be from a village, she could be poor, but the faces of the kids clearly show that they are in a safe custody. The smile from the faces of the kids will show that these children are not abused. These children are lawfully in they are in a lawful custody. So this tells us that lawful custody is a very important foundation to happy and protected children. That's why the slide says that children are generally weak, they are mentally immature, economically dependent, and they are significantly illiterate. So parents have a very important role to play in ensuring that their children are protected. One way of ensuring this protection is to make sure that parents come into contact with children, get custody of their children through lawful means. I repeat, through lawful means. Next slide, please. So it says that childhood is a very delicate stage in life. We know that we all pass through this stage. And your childhood plays a very vital role in who you become when you become adults. So at the age or at the stage of childhood, children must be raised by the family. And it is generally discouraged to institutionalize children or to raise children in a formal government facility. So it's always good to have children raised within the family because it plays a lot of role in their safety, in their psyche, and the way they look at the society as a whole. To that extent, we say that the Child Rights Act 2003, and of course, many of our laws have spoken very well with respect to issues of custody, with respect to issues of parental child abduction. Yes, next slide. Given the fact that when you want to raise children, you have to ensure that you have lawful custody of these kids. And the striking laws that protect children or that talk about child protection in Nigeria, there are a lot of laws. Of course, we have the conventions, for instance, the Convention on the Rights of the Child, 1989, which Nigeria is a signatory. We have the African Charter on the Rights and Welfare of the Child. Nigeria is a signatory. Of course, we have the Constitution of the Federal Republic of Nigeria, 1999, as amended. We have the Child Rights Act, which is the most comprehensive law on child protection in Nigeria. We have the Penal Code, which applies in the northern parts of the country. We have the Criminal Code, which applies in the southern part of the country. And we have the VAP Act. Various states, or almost all the states in the Federation, have passed the VAP law, which also talked about issues of abduction, which also talks about issues of abuse of children. One cannot differentiate, one cannot take away abduction from child abuse because it has a direct linkage with the safety of the child, with the way the child is crime. Because if we stop at that, we are forgetting the most important thing, which is the future, which is the child. In addition to taking the necessary legal steps against any parent that has done that, we should also be mindful of the fact that children suffer, children are abused as a result of parental child abduction. Next slide. As far as Nigerian laws are concerned, the laws talked about abduction, but specific on parental child abduction, this we have to look at the laws and we have to appreciate the meaning of the law to say that, yes, this part of the law which talks about abduction, of course, includes parental child abduction. As a foundation, who is the child in the first place? Nigerian law, the conventions which Nigeria is a signatory, have defined a child. The Convention on the Rights of the Child, which says in its Article 1 that a child is every human being below the age of 18 years. And it has given one, opening to allow states, to allow countries to decide be above or below the age of 18 by stating that under the applicable law of the child, majority is attained earlier. That means that latitude is provided to countries who are signatories to the convention to decide which age they want to put as the age of maturity. And we have the other international conventions that like the ICCPR, like the ICESCR. All these conventions have defined or have mentioned who is a child. However, deliberately, these conventions did not define, give specific meaning of who is a child. But when we look at Article 24 of the International Civil and ICCPR, it says that though the convention does not define who is a child, however, a child or childhood ends at the age in which maturity is attained. So what age is the age at which maturity is attained? This will look at our various laws, and these laws will define or will determine at what age maturity is attained. Next slide, please. When we look at the laws in Nigeria, we understand or we appreciate the fact that childhood ends at the age of 18. The Child Rights Act 2003, which is the most comprehensive legislation on child protection in Nigeria, defines a child as a person below the age of 18 years. The states, all the states, I'm happy to say that all the states of the Federation have all domesticated the Child Rights Act. Some named it Child Protection Law, some named it Child Rights Law, some like Kaduna, they named it Child Welfare and Protection Law. So all of them have defined children, and most of these states also put the age as 18, meaning that childhood ends at the age of 18. Next slide, please. So looking at this, we want to now jump into the major aspect of our discussion, parental child abduction. Parental child abduction involves parents. Of course, after the dissolution of marriage, issues of custody will come up. And then parents that are unable to get the custody of their children sometimes resort to issues or resort to unlawful means of getting the custody of their children, and that is what leads to abduction, meaning that they unlawfully take the children out of the lawful custody which the court has already awarded to one of the parents. And when we look at the Child Rights Act, Section 68 of the Child Rights Act provided that the family court has jurisdiction over issues of abduction. Section 71 also puts that the welfare of the child should be of consideration whenever the court is awarding custody of
Doctor,
yes.
Good data. You have 5 minutes more. I just thought to
So
let you know.
next slide, please.
So
Next
you
slide.
can watch through. Yes.
Okay, thank you. So there are a lot of causes of abduction. Ignorance is one of the causes. Some do not know the law very well. Greed, psychological causes, because some will say without their children they cannot live. Poverty, maybe punishment. Of course, where sanctions are not applied as it's supposed to be applied, is also a great challenge. Issues of corruption, when some see that they have other ways, they have their ways to go around and have the custody of their children, even without following the due process of the law. All these things play a lot of role in causing parental child abduction. Next slide. And this comes with consequences, because when children are abducted, they are separated from their environment. And in the course of doing that, because illegality is involved, they often try to hide these children. In doing that, the children can be physically harmed. The children can be psychologically affected. It can affect their education and lots of other consequences. All the three major types of child abuse can come up as a result of child abduction. So that is why, as I said earlier, we should always be mindful of the fact that we look at a parental child abduction beyond what is in the books, beyond the punishment. Look at the consequences on the child. And Section 2 of Section 1 of the Child Rights Act is clear that the best interest of the child shall be of paramount consideration. Next slide. The laws on parental child abduction, of course, a lot of sections have spoken about that, like under the CRA, that is Child Rights Act, Section 27 has mentioned parental child abduction and prescribed different types of punishment ranging from 25, 20, 15, 10, and even the last one is 7 years if it is within the state. But if it is outside the country with intention of not bringing the child back, it's up to 25 years imprisonment. Next slide. So other laws have equally made provision for that. The Penal Code provided for 10 years for abduction. The Criminal Code, next slide, has also provided similar provision as far as punishment is concerned. Section 371 of the Criminal Code has also made provisions and punishments for abduction. The VAP Act, next slide, has equally made provision. But of all the laws, what I've noticed is the VAP law provided for the least punishment. It says not exceeding 6 months and fine not exceeding 100,000 naira. In terms of the fine, the VAP law has a higher fine, but in terms of terms, of prison terms, the VAP law is the least. So these things we should always consider as well. Nigeria is not a signatory to the Hague Convention on Civil Aspect of International Child Abduction, which is an international instrument that looks at parental child abduction. But in the course of, next slide, in the course of my suggestions, we suggested that, of course, Nigeria should ratify the Hague Convention, that is one, and our laws should be amended to specifically address parental child abduction. When we look at the laws, they are on abduction generally. They are not biased or they are not specific on parental child abduction. So that is a way to look at it, to address it squarely. Our laws should also look at that. Our courts should be bold to administer the punishment as it were, as it's supposed to be, so that that will serve as deterrence to both private and public deterrence can be attained if courts also administer punishment as it's supposed to be administered. Next slide. The next suggestion is also trying to create awareness on the effect. Most of us are looking at the criminal aspect of it and downplaying the consequence on the child. So the consequence of the child may not be felt immediately, but with time, it affects the society, it affects the child, and as such, parents should be cautioned about both the consequence on the child and the legal implication, because they can be prosecuted, they can be punished, they can land in prison for abducting their own children if they follow unlawful means of doing that. And in conclusion, we say that parental child abduction is a matter of serious concern. Our laws have made abduction a criminal offense, but several push have been made, or several factors are responsible for parental child abduction, as mentioned earlier. However, parents, the society should be made to appreciate the consequence of parental child abduction on the child and on the society, in addition to the punishment prescribed for the offense. Thank you.
Thank you very much, Doctor. Thank you so much. I don't know if we can actually give you a round of applause. Please, in the comments, please let Dr. Umar know how his presentation went. Thank you so much. You have thrown so much light and brought to light the reasons why parental abduction actually happens, from ignorance to greed to poverty to corruption, knowing I can have my way around it without actually thinking of the effects of this abduction on the child. Thank you so much. Your presentation was well researched And I know that the slides will be available, the content will be available for our participants. So once more, Doc, thank you very much.
Thank you, my pleasure.
All right, so next we're moving to our next presenter, the next panelist, who will be presenting straight away. He will also be talking on parental child abduction, none other than His Worship Elkanah Eyinda Oge. He will be discussing this theme from the perspective of the bench. Your Worship, please, you have the floor.
Okay, good afternoon. I hope everybody can hear me.
Yes, we can hear you loud and clear, and we can see you too.
All right, thank you very
much.
I am sorry, I will apologize. I don't have much slide to share. I wrote a judgment and I have sent it to the committee, so you will take time to read it. I got to know that I have to put it in the slide just late, and that's stupid. Although I have, okay, they have been able to do so. But let me say, I think our issues for discussion today are narrowed, basically on the concept of a parental child abduction. How many minutes do I have so that I can narrow my discussion?
15 minutes, sir.
15 minutes, okay. So the issue we are looking at is the issue of parental child abduction. The first two speakers who have spoken have given us a definition of each on the concept. That is a parent taking a child away or retaining a child from the other parent against the parental rule or custodial rights of the other parent. Basically, it is an issue that has a lot of consequences that I will talk on later. But I would point out this. One, we need to understand the differences in the issues of parental responsibility, parental custodial rights, and the issue of I didn't get that. Okay, the issue of custody and the issue of parental responsibility and parental child abduction. When you have parental responsibility, you may not need to live with the child. Once you are recognized as the father or mother of the child, the law confers on you that responsibility. And parental responsibility is nothing but the authority to make decisions as to the residence, health, medical issues, and other issues about the child. Custody only comes up when there is a pronouncement or a sanction from the court. When the court makes a pronouncement, okay, in an event, this relationship between the couples are fractured and there is a separation or divorce, that is when any of them can come to court that on this basis, on this fact, court grant me custody. Now, when custody is given in such situation, the other person may be granted right. So when a child is adopted in a marriage situation, before divorce, both the mother and the father of a child all have custody of the child. When in a situation where there is an issue in the marriage, that is when the issue of now who has custody comes. So where the other parent takes the child away from the other person without the sanction of the court, that is what makes it an issue. You take it away, and you now, by taking the child away, you are depriving the person of the exercise of his parental responsibility on the child. And you know, it takes two to tango. It takes the influence of the father and the mother to raise a proper child. And the child also needs to know about the father. And one of the issues is about when a parent adopts the child as against the custodial rights of the other parent, it has a way of, distorting the child's understanding about the other parent, makes the father child to see the other person as a bad parent. So these are one of the issues we need to understand. And then two, on the applicable laws, we have the Child Right Law, Section 27 of the Act makes it clear that nobody should take a child away from anybody who has custody of that child. And then also, we also need to know that parental responsibility is not only conferred on the biological parent of the child. Parental responsibility and custody can also be granted to somebody who is not a biological parent of the child, i.e., for example, somebody who had approached the court for custody, somebody whom the court has given right to foster the child, somebody whom the court has also granted parental responsibility or a word of the court. At that instant, the child becomes the responsibility of the court. Somebody who takes the child away as against that right of those other people is also adopting the child. And there are instances where persons who are parents of the child can lose their parental responsibility or their custody right. Example, if you have a child and you abandon that child or you desert that child, or you are a parent of the child, you are careless as to the welfare of the child. Another person is playing that role. If that person approaches the court for the grant of custody and the court does that, you may be a parent, then you lose that right. I mean, you lose that right of custody for that child. So the fact that you are a parent, a natural parent of a child, does not actually give you always ensurement, or don't mean that you will always have custody, or you will always exercise parental responsibility of a child. That's why most people come to court. They apply most times, even the parent of the child will come to court. Yes, court, the person will apply court, I want to have a legal custody and sole parental responsibility of the child, even when the parents are alive. Most times, looking at the situations around, sometimes the parent contests, some they don't contest. But when you look at all the facts in the issue, most times the court will give custody and parental responsibility to a person who is not even the biological father or parent of the child. And if anybody who is a natural father or parent of the child takes that child away, that also is also adopting that child as against the order of the child, or called vesting responsibility, the parental responsibility or custody on that other person. And then another issue is that when you talk about parental responsibility, when you have parental responsibility, it does not necessarily mean you have to live with the child physically. Now, parental responsibility only gives you right of decision-making, authority, as to participate in the welfare and in the issues about the child's upbringing. But custodial rights encapsulate both responsibility and the right of physical, staying with the child. So when somebody who has parental responsibility, custody, has rights to stay with the child, and also the right also to make legal decisions on the child. Legal decisions, I mean decisions as to the school, medical issues, welfare, and other issues that has to do with the child upbringing. So let's get that clear. And then now, on the issue of applicable law, I mentioned earlier that we have the child right law, who prohibits anybody taking away a child from the person who has custody of that child. And like another point, I also want to point out that custody of a child can be acquired either that you are a natural father of the child, parent of the child. When you are a natural parent, when the both parents have, the custody can also be conferred by the court in an event where they are not, the parents are not playing their role. So custody can be come by way of your natural parent, or also you are conferred by the custody by the order of court. So I go back to the applicable laws. You have on the applicable law that we're looking at issue of parental child abduction that safeguards the issue of adopting a child or make provision. One, you have the child right law. You can look at section 27. You also have section 20, who talks about the listing on the issue of what a parent of a child, the duties of a parent of a child to a child. You have section 227 of the Act that talks about that spells out what parental responsibility is all about. A person who can exercise this rule on a child has parental responsibility on the child. And then section 27 makes it a criminal offense when somebody takes a child away from the person who has custodial right and exercises parental responsibility from the person, so that the person no longer exercises that authority and power on the child. So that is punitive. I will talk on that later if I have time. And then you also have our immigration law. Immigration law, particularly when it has to do with foreign abduction. Immigration law does not allow a parent to take a child outside the shore of Nigeria without a written consent. Remember, I didn't say just not the ordinary consent, a written consent of the other parent. Check regulation Regulation 40, I think sub-regulation 4 and 5 of the immigration law. So that is made to safeguard in a situation where somebody can easily sneak a child out of the country. But we see in practical cases that come to court, most times that happens. Some parent takes their child out of the country, even in the existence of that law. How they do that, we get to know. And then we also have the Matrimonial Causes Act, who provides in section 70 that provides for the power of court, the High Court, to make order as to custody when marriage relationship is fractured. You also have the criminal law that provides against taking a child away from the parent. And in that circumstance, now the issue now that we have to look at, the issue of parental child abduction is peculiar. Peculiar in the sense that it is a parent that is taking the child, not a stranger, from the other parent who has right of custody or who have rights to exercise parental responsibility on that child. So that's why it's peculiar. Now, the reason why, we talked about, also looking at the law I mentioned here are the local laws. Now you also have the foreign law or international law that tend to look at this, because this issue has been a serious issue that affected many families and people across the globe. So at the international community in 1980, there was this Hague Convention that tend to serve and protect on the issue of parental abduction, on the civil aspect of it. You know why it is civil? Why they are looking at this issue, that this issue, ordinary, society tend to look at it, it's a family issue. But then there are the other fallout of it. The impact it has on the child are not the left behind parent, whom the adoptive parent is depriving the right to exercise that right. So that is why the modalities or the manner of the international the convention, the Hague Convention, is to approach it on a civil approach, because a family issue. The parent who is adopting may have his or her reason, and it could be good. Okay, I'm taking each other away from this person because it's the person is violent, his relationship with the child is toxic. But you see, the problem they have is that they ought to have approached the court. In a situation where you sense, oh, my relationship with my child parent, mother or father is toxic, is fractured, I think one of the ways to prevent you running into the issue of the challenge of adopting a child, and that's in some country will make you liable for criminal prosecution in a situation, in a system that do not have the Hague Convention. So what you should do, approach the court, come with, by way of motion, or look at the relevant rules of the court or rules of the court, make an application. The court will hear you. Once you come to court, the court will invite the other parent. Okay, your wife said you want to have custody, and then probably also the court should give you a right to travel overseas, or that the court should give you joint custody. When the court hears the both of you, and there is a stamp of the court, a sanction of the court on it, you are free from all the challenges and the problems of you snatching the child. So people do it because they are ignorant. And then two, another issue that has to do with this with when somebody adopts a child and take the child outside the shores of Nigeria or anywhere. Okay, let me just point out. Yes, we have domestic child abduction. You take the child away. People living in Port Harcourt, even Port Harcourt, you just hide the child. You don't allow the man. But we are looking at the implications it has both for the child and the parent. So whether it's foreign, the effects are the same. And that is what we are trying to do, is to stop it. And the one way to stop it, the local one, is know that the court exists. The court will hear you. And good enough, the rules of the family court law that now deals with these issues are made to be, done acceleratedly. To matters that have to do with children interest because of school and other things, we'll attend to it with dispatch. So within dealt with, and then they will decide, okay, this person should have custody, or this person should not have custody, this person should have access right, and all that. So people who are involved in all this, or counsel and lawyers who deal with these people, tell them the best way is to go to court. Leave the fear aside. You can tell the child, but go to court, and the court will have the power to direct on what should happen. And then two, another aspect of what, okay, when somebody adopts a child and takes the person outside the shores of Nigeria, one, if Nigeria is not, like pointed out by the other speakers, Nigeria is not a signatory to the Hague Convention. It is very, very tasking, particular. and very difficult for the child to be returned. What would happen is that if Nigeria has a bilateral relationship with that country on the issue of observing and respecting its law, all you need to do is to do what? You can initiate the process. Initiate the civil process in Nigerian court there. Once you get a court to satisfy and the court grants you custody of that child, all you need to do is what? File that process. And there is a bilateral relationship. File that process in the court of the other country, or you can embark by contacting the embassy, attaching the order, and then the order of court has to be clear, stating that the child that you have custody, that the child should be returned back to Nigeria. When you've gotten that, that is when you can commence the process of seeing how you can register that judgment in a foreign court. Why Nigeria have that bilateral relationship with that other country. Then on the other side, in a Hague Convention country, it's simple. The process is just, the conventions allow the country that are signatory to that to create what is called central authority. Central authority, are the authority that takes issues, collect issues. Take, for instance, if Nigeria is a signatory and then the child is adopted to Australia, all I need to do, once I notice that the child is there, all I need to do is what? Get the location, the state where they are, and then notify my central authority, which is usually manned by the Office of the Attorney General of the particular country, and they will notify. Just try notifying the country of the Australia will not take it upon themselves. All you need to do maybe the pay cost and look out for where the child is, and based on that the status of being a signatory to the convention, the child will be returned to you. But where the country is not a signatory, what happens is that what you need to initiate first, either you think of initiating a process in your country. Once you get the order of court giving you the status that you have a responsibility and custody, you can now register that judgment. And time will fail me, I will have explained on detail. Then the other one too, you can also check out what works in that country. Like in America, there is what is called a unified child.
Your worship, I'm sorry. You have taken almost 20 minutes beyond our time. Thank you very much. So we still have one panelist who is just going to share her experience with us. I think during the question and answer session, a lot of questions will come and you will be able to address them. Thank you very much, sir, for your in-depth analysis. I feel like just taking the doing internship with you, because as a family law practitioner, the real situation is when we are faced with these matters, what to do to help our clients. Thank you very much, sir. I would like to call on our panelist, Ndidi Anike. Ndidi, please share your experience. Today, you want to share your experience as a practitioner in the field. The next 15 minutes, please share your experience on parental child abduction and what you've seen in the field, and so that we can all gain from the experience, and hopefully we can get answers to the questions that we have. Thank you very much. You have the floor. Didi, are you on this call? If you are, please, you have the floor.
Thank you. Can you hear me now?
Yes, yes, we can. Loud and clear.
Fantastic. Thank you so very much. I just want to briefly thank all the other panelists. I have learned so much from their wealth of knowledge and experience. And thank you too to the NBA leadership of the section on legal practice for this opportunity. So I'm going to, we've heard all of the laws and all of the practice measures that has been applied in both the UK, as it were, the laws. I'm not going to even bore us or go back to all the laws or what a child is and all of that. I'm just going to come from a practical point of view, right? And I'm going to come this way by telling 3 stories, live cases that I am currently handling right now. Number one.
You have 15 minutes, Ma.
Yes, I know, and you will get the gist. You will get the gist from the story.
Okay,
number one, this lady and this young man were not married, and somewhere along the line, there were the relationship, and the young lady got pregnant, and the young man denied the pregnancy. And long story short, the young lady was kicked out. She had the baby 2 years after. She got an opportunity to travel to the UK as a nurse, and she had to leave her baby, whom she's been with all this time anyways. No help from the man, no word from him, from the biological father. And then she travels to the UK with plans that she's going to take her baby later. And then immediately she leaves for the UK, the man gets an order from a customary court granting him custody of the child, who, by the way, is a 20-month-old female. And then he comes very early in the morning because the child was left with the maternal grandparents. And then he comes very early in the morning, Gestapo style, with policemen, arrest the grandparents and take this child to an unknown place. And our attention was alerted. And then we, of course, did a counter petition and quickly went to the court, to the family magistrate court to be precise, because they weren't married, to gain custody, legal custody of this child. That's the first scenario. And of course, somewhere along the line, this young lady, the court granted interim custody because the baby was ill. There were so many issues, interim custody. And then while we're waiting for the substantive matter, the young lady comes in from the UK, takes the baby and leaves. That's one scenario. The second one, two people again, not married. They have the first child, who is a 2-year-old girl, and she had a medical condition. The young lady had a medical condition wherein she was advised not to have a baby again. Meanwhile, all this time she's been living together with this man. Family members were not aware because somehow the man found a way to lock everybody out. And then the family members only got to find out that she just had a second baby. Nobody was aware she was pregnant. And in the process of having the second baby, she gets into a seizure and dies. As we speak, the baby is in the incubator. And while all of this is happening, remember, these two people are not married. The young man uses the police to arrest the doctor in the hospital where the baby was born, and then gets an order saying that the child must be released to him. Meanwhile, he has gone ahead to abduct, if I may use that language, the 2-year-old, which is a baby girl, to a place unknown to the family of the deceased young lady. Now, the third case is, this time around, is a man who was married to a young woman, and somewhere in the middle of the marriage, the young woman abandons the home and travels to some place nobody knows. This young man took custody of the child, who is a boy, has been taking care of the boy, and somewhere along the line, this woman comes in to lay custody to the child. Somewhere along the line again, we find out that she has been involved in prostitution. It was proven, and for fear of the welfare of this young child, the man takes the boy and travels to the United States. Now, these are real life situations, because I'm saying this because the papers have addressed the issues of legal custody, when they're married, and, in the event of a divorce, who takes custody of a child and all of that. Nobody has also drawn our minds. We need to draw our minds to the fact that there are also children who are born outside wedlock. Who takes custody of these children? There are children who are born and one parent has absconded and the other parent has been taking care of this child, and then suddenly the other parent comes back and says, oh, this is my biological child. What is the position of the law? So this is where I am going to be coming from, because we are not even questioning paternity or maternity, as it were. In my own case, we are looking at the issue of legal custody, which simply means having legal rights to make decisions about a child's well-being and upbringing. And just like the other panelists have rightly pointed out, some of our laws are a bit silent on the issue of parental abduction. But then again, you want to look at the issue of the interests of the well-being of this child. The paramount interest of the well-being of this child is what is most important to the court. In the first story that I told, this is a young girl who had this baby and was nurturing this child, got a job opportunity to travel to the UK, and then suddenly, out of the blues, the biological father shows up and comes to lay claim to the child. And you want to now ask the question, why now? Where have you been? In fact, in the course of investigation, it was discovered that the young man runs a brothel. And he's not even claiming custody because he wants to keep the baby. He wants to hand over the baby to a sister of his, who we have now found out through private investigation by the police is a prostitute in the brothel. So now, what will you say in this case? What will the court hold in this case if he alleges, oh, this woman to whom was temporary custody given has abducted with my child? What is the court going to look at in this matter? Is it the fact that the woman has abducted the child, or is it even the interest of that child? Because you want to start asking, you that is asking for the custody, what can you do for this child, given your antecedents and given all that has been said of you, which most of it you didn't deny? And so I am looking at the real life situation here. We are dealing with legal custody. Most of these children, their parents were not married. In the second scenario, this young lady wasn't married to this man, but they were living, they were cohabiting together. And then she dies in the process of giving birth to their second child. And now the young man uses a court order to want to take custody of the child in the incubator, as well as having taken away the 2-year-old child to a place unknown to family of the young lady. Now, I want us to be a little bit more proactive, and this is where I'm coming in from. As much as we abhor and we disabuse, or rather do not encourage any form of disobeying court orders, as much as we are up for not advocating for self-help, but you also want to look at each case based on its own peculiarities. And this is where I will suggest that our law become a little bit more innovative and proactive to consider cases such as this, like the cases I have told you about. Because if you are asking for custody, the equitable principle of he who comes to equity must come with clean hands must also apply. Where have you been and what have you done? What have you done in this child's life? And what are you even doing now? Even in your process of asking for custody, are you even relying on the law? Are you going about it the legal way? Because customarily, where I'm from, customarily, when a man is married to a woman, in most of the customs, especially where I'm from, the custody of that child automatically reverts to the father, right? So it is clear cut. It is only in some cases that the court will want to look at things like the age of the child, the gender of the child, the ability of the parents asking for custody, and all of that. But now there are real life situations, and that is why you have the family magistrate court that deals with issues of children out of wedlock when there are no matrimonial issues. When you're talking about custody statutorily, you're looking at the Matrimonial Causes Act, and that is the High Court. But when you're looking at the issue of custody solely, without hanging on any of the matrimonial reliefs, then you're also looking at the family court, in this case, the family magistrate court. And so in the first instance, in the first story that I told, the issue now is the lady in contempt. And I want to quickly say, based on my own knowledge, the temporary custody, the interim custody that was granted the lady and her parents, or the temporary custody that was granted to the lady and her parents. In other words, she has temporary custody, interim custody, her parents have interim custody. Now, if you claim that the woman has abducted the child and taken her out of the country, on what claim will you be laying that? Because you were only granted access according to that order. And these days, Irene and the other guests on the program, you will agree with me that access can be done. It mustn't be physical in most cases. And we are looking at the peculiarity of this case. You don't even know the name of your child. You don't even know when she was born, right? But the court can also make an order of access, widening the scope of access to say, I mean, we have legal proceedings today that are streamed online, right? Virtual proceedings. You can still maintain access with that child. And now, can you also accuse or hold in contempt the grandparents of the child for an act of the mother who came in on her own, took the child, and left to the UK for fear? Because according to her story, and the reason why she did what she did when we did inquire, was that the man had been making threats, had told her that, oh, she has gone to the UK, he will make sure that she comes back. He will do everything. So she has gotten wings to fly. He will do everything to bring her back. And that he has done it before, that he has arrested that child and taken that child to an unknown place. He will do it again. Now, for fear of that, she acted and did what she did. So these are some of the real life scenarios that we see. And I want to look at it again as, did she break the law? If you want to look at it, if you want to discuss this, did she actually break the law if she was given interim custody and the man given access? I'm not going to answer that question, but you want to look at all, like I said again, all the peculiarities. These are real life issues that we are dealing with. And so back to the question again, parental abduction. The definitions have been given. And you can look at the definitions. It is within the context of quote and unquote marriage and after divorce, right? And even when that happens, the law will be brought to bear. Now, in the question of where both parents, biological parents, were not married and access was given to one parent and custody was given to the other parent, can the parent to whom access, even though it's interim, whom access was given to, not be allowed to live with that child anywhere where he or she is for the purposes of taking care of that child and catering to that child? Are we also going to say that because you have access, access must be physical? Access must only be when you come to touch the child? This is a 20-month-old child we're talking about, barely 2 years old. Are there not other ways where access can be enforced in the best interest of the child? And so this is where the angle where I am coming from, and we've been trying to handle some of these cases. But as far as I'm concerned, I think that the courts have to be a little bit more proactive on our laws and a bit more pronouncing on some of the silent areas, especially with children whose parents are not legally and lawfully married. What will the court do, and how can the court ensure that the interest of that child is protected? Thank you very much.
Thank you very much, indeed. I can say that you're within time. You kept to your time. You promised from the beginning. Thank you for throwing up these scenarios, because it's one thing to just know the law, another thing to look at the scenarios, the things we face, the cases that we see daily, especially with the unmarried. I would like to call on His Worship. I'm very sorry, I cut you off before time, so I'll be giving you your 5 minutes. I noticed that I didn't give you all your time, please. His Worship, Elkanah Oge, I don't know if you would like to conclude or you'd like to speak to any issues. Please, you have the floor briefly. 5 minutes, sir. I'll also be calling on the other participants, the panelists, if they have anything to say before we take on the question and answer session. If you have anything to say, His Worship, please. Or if we don't have any questions or further conclusions, we can just go straight to the question and answer. Okay,
can you hear me now?
Yes.
Can you hear me?
Yes, I can hear you. Go ahead.
Let me start from the aspect where she said they mentioned the cases where the people are not married. I want to observe, with due respect, I think the basis for any rights over a child is not basically that you are the biological parent by virtue of the Child Rights Act. Like I said, parental responsibility and role or custody of a child can be acquired by 3 major means. Either you are the natural parent of a child, or by guardianship. Guardianship can be conferred on you by the parent of the child. If they say, okay, take care of the child, either by the agreement or by the order of court. And now, for a parent who are not biologically married, Section 68 of the Act provides that when the parent of a child are not married, or the child is out of wedlock, that either of them, the mother or the father, can apply to the family court for parental responsibility. We have quite explained and defined what parental responsibility means as authority, power, and right to make decisions as per a child. Parental responsibility does not confer custody. It only gives you power to make decisions and to decide, so that the person who may be in custody of a child, when making major decisions that affect the child, will always consult you and won't put you out of it. So when court grants you responsibility, you may not have custody. Custody has to do with physical presence with the child, and which also goes with parental responsibility of that child. So somebody who does not, who has the child, maybe out of wedlock, can apply to court. And we all are aware, the court recognizes the fact of the existence of a culture where some people say if the child is not married, it belongs to the mother or the father. That is the essence for that provision. So naturally, the mother always has custody. The mother of a child has custody. So the law in section 68 make this provision to take care of this situation. Like also, she also pointed out in a situation where somebody has not been there in the life of the child and only is coming up later because of one interest or the other. That is the more reason why the court exists. In a situation like that, don't act arbitrarily. Come to court. If you perceive any threat as to your interest or as to your right over the child, that the other person is threatening it or is being threatened, you approach a family court. We in River State here, we have what is called safe home, where there is a threat over the safety of the child. We make order where in the law, but I think in the act, and in our law, we have what is called emergency protection orders that the court can make, assessment order that the court can make. You have care and supervision order that the court can make. You have education supervision order. These are under part 4 of the law and part 5. So under this part, there are various protective orders that the court can make where you perceive that the child's safety is threatened. The parent of the child can, acting through the Ministry of Social Welfare, which is the appropriate authority, or the government, can come based on information an interested person, applicant, supplies to the court or to the ministry. And then when they approach the court, when the court looks at it, and then in emergency protection order, supervision order, assessment order, all these applications that can come to the court as party. So you don't need to invite the other party, make that order first. The court will issue the order, serve it on them, and then ask you, okay, now come properly by filing a substantive motion of notice or suit. And then when the other party comes, by the expertise order, the court can direct, okay, this child should be taken to safe home, or this child in the interim should be done with this person, and this person don't have anything to do with this child until we decide on a substantive application. So I think that can take care of that. So, but the basis is a what? Where there is an established father of a child, or somebody who has a guardian, a guardianship role on the child, or somebody who the court has given custodial right, may not be the parent of the child. For you to take that child away from that person, you also need an order of court. That is why in section 70 of our own law, I think 69 of the law allows for situation not on appeal. When the trial court, who have heard matters of custody, grants you custody of a child, the other person can, if there are circumstances that has changed, and approach back to that court. Court, please, from what I'm seeing, this order you have given in the favor of this person, please, I want you to vary it. I want you to alter it. I want you to discharge it. And if there are situations that will warrant the court to alter, to discharge, to vary, the court can. So all we're saying in essence is that there is no need for anybody to adopt the child. The court is open for you. Where there is any threat you perceive, or you want to travel with a child abroad, you feel there's a better opportunity for you there, don't do it strictly. Don't steal a child. If you do, you will be running against the law and you will proceed against criminally. If you do, when the person reports it, if the person feels that he does not have the means, the financial means to proceed through the civil procedure by filing the case here and registering in a foreign court for the child to be returned, if they report you to the police and the matter gets to the Interpol, you will be under trail. And in the foreign country where you are, you'll be living in fear. When the child is apprehended and you'll be returned, deported back, and you will lose your right of going back to that place again. So these are the implications outside the other impact that the thing has on the child. And one other challenge you see people don't know is that when you steal a child, you affect that child in many ways. One, when you steal a child, one of the things you do that what you hide their location. You tell her about the child. And if you don't hide a location, you change locations. If you live in River State, Port Harcourt today, the other day you want to live in Aba. In 2 months, you want to live in Uyo. In the other month, all because you don't want that. But these are the things that if you have come to court, you would have, easily gotten the relief of the court. Okay, Mr. Ngozi, stay with the child. And that will obviate, leave out all this pressure of living in fear. So tell those of us who are in practice, let us tell our litigant, our client, that the best approach, whenever there is a fractured relationship and your client perceives that there is a fear and that he needs to stay with the child, rush to court. The court will hear you. If you feel, oh, before they hear, come by way of ex parte. And then with the assistance of the ex parte application, we can hear the substance. Then we can rule. Okay, let me conclude. Whenever I still have the time, there is a particular matter we did. And okay, you know, in the family court or in anything that anybody is doing with respect to the provisions of child right law, you know, the stabilizing factor, or what I call the balancer, is the section 1, which is on the best interest of the child. Like she pointed out, and the best interest of the child, you know, overrules any other, even when there may be some rights. But when they go to look at the fact and circumstance of the case and sees reason to deviate from what is the obvious provision of the law, best interest of the child overrides that. I give you an example as I summarize. There was a case of a parent, a couple who went to the family high court. They got the resolution, and the court made some consequential order for the child. But I mean, in reference to the marriage, gave the mother the custody and has some access rights and maintenance from the father, and then directed that the man should be paid a monthly maintenance fee of 50,000 naira. But the woman was there, was not having a job, but somehow she got a job. Attempt to admit for the parent, the man, to give consent by virtue of the immigration rule. The man refused, but somehow we don't know, and that we don't want to know how the woman got, and then they went abroad with the child, and they lived for some time. So that when the passport, the child was had in America. When the passport, and then the mother got a job in UK. When the passport, this is a really story that I think I decided that about early this year or December. Now, when the passport about the child, the initial passport issued, which lasts for 5 years, was about to expire. The woman now, when they went to the embassy, they needed the consent of the father for the renewal, and that becomes an issue. So they tried, the embassy gave her 5 months. After that, now the challenge is that either passport expires, since it's a minor, it takes a longer time, and you will almost proceed as if you are a fresh applicant, and is difficult. So when they came to court, she's hired a lawyer here. We did that, but I looked at all the facts of the case. Now, what came to my mind was what the best interest. The child already was schooling in UK. If the mother comes back here, she may not have a job, and the man will only pay 50,000 naira for maintenance. The woman will have to pay for accommodation. The other didn't give. So I look at the circumstances of the case. The man was not willing. All she wanted was what? Come back here, let me feed the child. But I look at access cannot only be physical, like she pointed out. You can have access, like we are talking here now. Some of us are abroad, we are having access, we are talking, and then so access must not be physical. You can use that, you can access the child through all these electronic gadgets. After I tried to pander them to mediate, they were not willing. So I ruled. And what made the decision that the man is given some time to go to the embassy of the UK embassy and send a deposit of his consent for the renewal of the passport. If he does not, you know, I made an alternative relief that the mother should go to the embassy with this order of court, and that the embassy should grant her the power to renew for failure of the listing. And I based my ruling. And when it was served on the embassy, they were reluctant. But when they asked for the enroll order and the type out proceeding of the court certified, when they sent it, they saw the reasons for which I based, and that it was on the concept of the best interest of the child. Despite that the child was adopted. I see the case here. The child was adopted, but we're looking at the man was fighting with the wife on their own interest. But when we look at who is caught in the storm here, the child who is innocent. And if the child loses her American passport, it will be difficult for her to get it. So on that basis, I said, okay, mother, renew. And I told the man, if you want access, which the court gave you, there are other businesses that come back to court, and we will look into a matter and grant it. But for this interest, don't deprive this child of her right of losing her American passport. So I would have spoke on this thing, but if the time talk on the issue of the impact. If you look at the impact of what adopting a child outside the knowledge of the person who has a custodial right or responsibility over him, it is quite disturbing. particularly as it has to do with the age of a child and affect other disorder as the person grows up. So, and one other thing I also want to point out, once you observe that your partner has adopted a child, the law requires, like in America, you are required to make the move within 6 months. Reason being that if you don't make the move and the child has stayed there for some time, the law will presume that, you know, the basis for asking for return of the child is on the ground that it is based on the place of habitual residence of the child, not on the child nationality, not on the nationality of the child. It's a place where the child has always known to live with the parent who has custody. Now, if after 6 months for America, you don't make that move to apply, and you are applying, the American will say, oh, that the habitual residence of the child has changed. Probably the child has settled down based on the concept of what the best interest. And so you will no longer be held as to returning the child. And then on the other aspect is that what is, I think in UK is 12 months. I mean, 12 months, yes, 1 year. If you don't apply, if you observe that a child has been abducted and you don't apply, after 12 months, you lose this right of asking for that child to be returned. Although each of these is dependent, whether the court will allow for an application that is after 6 months or 12 months, depending on the country, is dependent on the fact and circumstance of the case. But one point we must know, the issue of asking for the return of the child, when the child has been removed from the place of his habitual residence, is the basis that this child lives in that place. Let me give you an example as a random. If I'm in Nigeria and my wife is South Africa, and we have all lived in Ghana, and it was in Ghana that my wife adopted a child maybe to the United Kingdom. If I'm asking for the return of that child, it is on the basis that the child should be returned to the child place of habitual residence. That is in Ghana where we are. I can't just ship to Nigeria and begin to make the application for his return to me in Nigeria, except where there is a valid proof that I have custody. So it is a place of the child habitual residence that determines whether you will be held in a foreign court where your child has been adopted to. Thank you very much.
Thank you very much, Your Worship. Thank you so much, everyone. Participants, thank you. Your comments are noted. And at this juncture, Ugochi Agala will be taking the Q&A. So I'll sign out from here. Thank you very much for having me. Ugochi, please, you have the floor.
Wow. Thank you so much, our distinguished panelists. We appreciate your brilliant contributions. May I specifically recognize members of the bench who are in attendance. Honorable Justice Elsie Thompson from the River State Judiciary. Welcome, ma. Honorable Justice Alero Akeredolu, we appreciate your presence. And His Worship, Sarah Albu, Bayelsa State Judiciary, we welcome you. Beautiful presentations. Specifically, let me mention the blessings from Honorable Justice Elsie Thompson. She said, thanks to the organizers and the NBA. God bless you all as we strive to protect our children. Now, the first question from Kwaji Joshua is directed at Olaide Awogbile, and it says, how do immigration laws and regulations intersect with parental child abduction cases, particularly when one parent relocates with the child to another country without the other parent's consent? This question is directed at Olaide Awogbile.
Yes. Can you hear me? Yes, immigration sometimes do have an impact on abduction. For example, which is a popular problem we have in UK. When a child has been abducted to Nigeria, because Nigeria is not a signatory to the Hague Convention, my understanding is that the child will be treated first as a Nigerian by virtue of the fact that the biological father is a Nigerian and he is likely to have an upper hand. Also, the father can unilaterally revoke the British citizenship of a child without the mother's consent. If the mother is going to come against the father, we will need to get a court order, and it's not going to be cheap and it's going to be very tough. So that is why it is always in the best interest of the child that we protect the child not to be abducted to a country that is not a signatory to the Hague Convention due to the immigration laws that regulate each nationality and each country. Then also when a child has been abducted from, for example, from Nigeria to the UK, sometimes the immigration may not really have an effect, depending on the issues that are being raised. For example, domestic abuse. If a woman is fleeing domestic abuse to the UK, obviously the laws of UK will override whatever that they had in Nigeria. In my slides, I talked about mirror orders. To a reasonable extent, mirror orders would help, but sometimes, like there was a case I did, the lady abducted the child to the UK and my client was a popular footballer. Now, story fast forward. Unfortunately for my client, we had to restart the case again, even though there was an order in favor of joint custody of the child. And what the position of the court was that, fair enough, they understand that the joint custody has been awarded abroad, but however, they need to consider the fresh allegations raised by the mother and reconsider the circumstances of the case, because obviously this incident happened abroad, but now the children are here in the UK. We need to consider their circumstances. And like I mentioned in my slide, and also your worship mentioned, we need to consider the length of time the children have resided in that jurisdiction. So those are things that could cause material change of circumstances that may override or may not override the immigration rules of that country.
Thank you so much, Olaide. The second question, what is the way forward where the persons with rights refuse to give consent for relocation? This question was asked by Christopher Daniel.
Okay, if the other person, now I'll be speaking from the UK point of view, which is a popular issue. That's why I use Canada, because our people tend to go to UK, Canada, or America. So for example, if one party is looking at relocating to somewhere else and the other party refused to grant consent, what you need to do is to issue court proceedings. The court will look at the welfare checklist, what is in the best interest of the child, the age of the child, whether it is proportionate for the child to move permanently abroad. I will cite two cases that I have done. There was one in which the child was around 3 or 4 years old. Now, the father opposed the mother moving the child abroad. Now, when the court was going to consider, the court considered that it was in the best interest of the child to relocate with the mother because, number one, the child has not started school. Number two, the child is not going to disrupt the child's education. The child needs the mother more at that age, and the court allowed the mother to relocate with the child abroad. Now, another instance where the court refused the mother to retain the child, refused the child to move. This was within the UK, where the child had a massive fallout with the mother, decided that was going to go and live with the father, but the child was about writing their GCSE. So in Nigeria, it's an equivalent of the child was in SS3. Here, the child was about writing their GCSE. Even though the child said the child did not want to live with the mother and wanted to live with the father, the court had to look at the circumstances of the case. It was not in the best interest of the child to change school and move from Manchester to London because the child was about to write their GCSE. So there is no general rule about it. It's all about on a case-by-case basis, a bit of common sense and what is in the best interest of the child.
Okay, thank you so much. We appreciate it. Our next question is directed to His Worship Elkanah Ogi. And I read, a mother took her children out of Nigeria without the consent of her husband, who had filed for dissolution of marriage. The father applied that the children be returned, and the court refused. What options are available to the father? So there's a note, a caveat to this. It says that the court is yet to make any pronouncement on custody. This question was asked by Ifoma Ezenwa. His worship.
In response to that, like we said, first, you have to determine how long has the lady, the adoptive parent, the Sorry, I didn't know I was not. I was muted. Like I said, first you have to determine whether the period, the duration of the period, the adoptive parent has been abroad with those children. If it has exceeded the 12 months, 6 months, or 12 years, it is a very difficult truth. The court will assume that the habitual place of residence for those children has changed, and you will not be heard. But where you notice that, like we also observe, what you need to do, go back to the Nigerian court. In America, there is what they call the Uniform Child Custody and Jurisdiction Enforcement Act, and also Uniform Interstate Family Support Act. That matter is to for all the courts in America to have uniform procedure on issue of child abduction, so that if state A makes an order, you know, in America is a federating state, each state has their own provision and issues of family law, so that in terms of where there are different or variant provisions of family law in a different state, by virtue of this law, you have a right. You have a right to register the order or decision of a court vesting custody on you to that other court, and that law makes a foreign country the decisions of a foreign the order of a foreign sees the order of a foreign country as sees a foreign country as a state in America. So what you now have to do in such situation is what you now go back to Nigerian court, ensure that your issue or your status as having custody of those children is clear. Go to court, ask the court to give you custody. The woman can be fined. In our own court here, we have a provision for electronic service of a process. When the court hears you and your issues that you have custody of those children is guaranteed, all you need to do is within that 6 month to 12-month period, file that process. First of all, you will need to do some due diligence. Get a private investigator who will need to investigate to find out the location where those people are, and also find out the identity. When you do that, then all you need to do is to register that proceeding in the particular state, the court of that particular state where that person is, by virtue of this Uniform Child Custody and Jurisdiction Enforcement Act. If you do within that 12 months, when that is established, like Olaide said, before the court also take the decision, there needs also to be a social welfare issues checklist. You need also to get that clear, that you have the ability to take care of the children there. Once it is established that the court in Nigeria has given you custody and that it is within that 6 month or 12-month period, I think the American court will also give return that child. But that takes a lot of time because it will involve engaging a private prosecutor. It will involve you making some kind of establishing some kind of relationship with the embassy where the order will be served, and then all those other things. And then it also depends if Nigeria has what is called a foreign judgment reciprocal provision, where the foreign judgment will be recognized in America, or where America law provides for a provision where the judgment of Nigeria will also be recognized in Nigeria. But generally, by virtue of that Hague law, most countries that are signatory to the Hague Convention tend to relax their issue when it has to do with enforcing a custody order coming from a court which may not be signatory to the Hague Convention. But before that complies, first it must be ascertained that the court will not presume that the children's place of habitual residence has not changed by virtue of the duration of time they have stayed in that place. So the engagement of a private prosecutor is important first. Find out the location, get a judgment in Nigerian court, get it cleared, find out whether the foreign judgment out of Nigeria can be recognized in that court. When that is done, just register a judgment and then you go. Or you can also commence a proceeding within that 6 months. You can get a lawyer with your complaint, comment a proceeding in that court by virtue of this Uniform Child Custody and Division Act, Enforcement Act. A specialist who is vast in the issue of a family law and child custody issue can also help you commence a proceeding, and the court will also hear you. And when that is done, your child will be returned based on the fact, on the peculiar fact of your case. Thank you very much.
Thank you so much, Your Worship. I would like to ask the second question. What can a father do where a court has given him full custody but discovered that the mother has taken the child out of Nigeria without the father's knowledge? Can the child be deported? This question was asked by Yemi Owat.
I think on that basis too, like I said, the major challenge we have in our own system is that our country is not a signatory to the Hague Convention. It makes the procedure so simple. Once it is observed that somebody has custody and the child has been adopted, once you report to the Central Processing Authority of your country, the Central Processing Authority of your country will have the role of reporting it to the other country, and they will look out for where the child is. The only thing you need to do is to engage the private prosecutor who will look out for where the family is, and without your order, you bring they will help you and bring the child back to you. But in an event where we don't have, and then what you need to do, like I said, is, so that question is similar. Find out whether the judgment of Nigeria can be respected, can be honored, and executed in that court. If it can, all you need to do is to go to that country, the courts, the particular state where they are, the city, register that judgment, and then the court will come into proceeding. The woman will be served. When she is served, and then she will come, she'll be given opportunity to be heard. After she's heard, if the court finds merit in your case, the order for return of the child will be granted. But that costs a lot. But like we said, one of the ways to prevent it is go to the immigration office. If you perceive that such thing is about to happen, just make a deposition that nobody should take your child or this person's children out of the country without your consent. Once that is done and there is a red flag, whenever there is an application, the red flag will always show, and the application for the immigration passport or document will be denied.
Thank you once again. Oshinowo Omolola would like to know where, if there's a pending criminal case before the court, will that case affect an application for parental responsibility in the UK, though the case had not been concluded? Your Worship, sir.
Well, I think, but let me think parental responsibility and criminal issues of a criminal liability. But for our own system, I don't know what the law or the position of the law is in Nigeria. Like we said, the law says when on issue of parental responsibility, where the parents of the child are married, the both parent has responsibility, and the responsibility is assumed to be more on the father. But where they are not married, the first assumption is that it's on the father, but any other parent can apply to court to be granted. So whether the person has a criminal issue or not, that will become the fact the other person who is opposing that application can lay before the court. So it is only the court that will see reason to deny that. So there is no clear application in our law that you have a criminal proceeding in court and will be the basis for the court not to grant you. It all depends on the fact of the case. But whatever is the position in UK, I think Olaide is in a better position to respond to that. This not so be one. Yeah.
Okay, thank you so much, Your Worship.
So,
The last question,
yes.
sir. Can a respondent approach family court for custody of her children when a divorce is still pending before a high court? She has not seen her children since the year 2020, and the divorce is taking so long.
Would you still want me to answer the previous question now that you've unmuted me? Wochi, would you still like me to answer the previous question? Can you hear me? Can you hear me? Would you still like me to answer the previous question, or Your Worship should answer the next question?
Okay, who is speaking, please? I'm not sure.
Olaide Awogbile.
All right, Olaide, we'll take comments from you, but when we're done with his worship.
Okay, all right, because he mentioned my name, that's why I said you should unmute me.
Yes, Hello, can we please unmute his worship?
Okay, I think in response to the last question, by virtue of section 153 of section 154 of the child rights law, let me speak specifically for River State. The family court is vested with exclusive jurisdiction to deal with the issue of children interest, even though the matrimonial causes are under section 1 has that jurisdiction. But where a matter is lying in the High Court on the issue of dissolution of marriage, where custodian issue is not there, I think the party are free to come to the family court and seek for that relief. On the other hand, where the custody issue is involved, that's the party can agree, or if the applicant is the one who is being bothered, or who is bothered on the length, the duration the matter has lasted in the or stayed in the High Court, she can ask the court that she's abandoning that claim and ask it to be struck, and then come, except there is no alternative or a counter claim by the respondent for custody. The party can abandon that or ask the court to strike out that relief and then come back to family court, because the family court has exclusive jurisdiction. You can either give it at the High Court or the family court level, and then the relief will be granted to you. But where there is a pending relief application in the High Court proceeding, and divorce is there, custody is there, until the court decides, until that relief is abandoned, the magistrate court cannot have jurisdiction. We can only have jurisdiction if you ask that it should be struck at, or if custody is not captured in their initial application at the High Court for dissolution of marriage.
Thank you so much, Worship. We'd like to call on my Lord, Honorable Justice, very.
Hello. Good evening. I hope I can be heard.
Hello, my Lord. We can hear you. You're welcome.
Okay, thank you. Good evening, everyone. In fact, it's been very enlightening for me because I just started presiding over the family court less than a year. So I was quite interested in attending this session, and I thank all the speakers. I just had a few comments because I know that the family law, the child rights law in states are different, a bit different. So like in Ondo State, all issues of custody, usually that's not customary custody. All issues of custody come to the High Court. So we have two modes of sitting, so to speak. We have where the family court judge sits alone to attend to issues of divorce and other ancillary matters. And then we have what we call family matters, where the judge sits with assessors to also take matters related to custody, adoptions, and all other ancillary matters. So I wanted to say with regard to the last question that you can even ask for interim custody while the proceedings for divorce is ongoing. You can ask for that, so you don't have to wait till everything is done before you ask for custody. Then you can also ask for access. Many times people are so focused on the end game, which is the custody, that even the access to give the period for bonding and all of that are not taken advantage of. So it's obvious to parties that you can have access. No parent should be denied access except there are circumstances that make it so. So you have to tell us in court the reason why the court were quite flexible qualities to prevail. So we usually want parties themselves and an instance of, because I'd heard of some of these fake orders that arise and are taken to the embassies and stuff. In fact, I had the embassy write to the High Court once asking me to confirm a particular order I gave. So, but in this instance, I find that some of the lawyers don't give you sufficient material to work with. So somebody comes and he says, I want consent to travel with my son. And she says the father is a lecturer somewhere in the East, and he has given his consent. He wrote a letter to the embassy and they attached that letter. And I'm like, this is age of technology. There are courts everywhere. Get the father to go to the High Court and swear to an affidavit, or get him to go to the notary public, or he should say, okay, he wants to be heard virtually. But you bring one letter that is a photocopy. Eventually, they ended up withdrawing that matter because they are very, very peculiar people. So whilst I travel with the children and the husband, so want to be, the consent is real, or that if he's not going to give consent because of the interest of the children, we would even override his consent, just like his worship said. If it is in the interest of the children, you can override his lack of consent and proceed. But then let's give the impression in the to lawyers, the litigants, that at the family court, things will be done expeditiously, so they don't have to go and look for the fake, and they will always get justice when they come before the courts. Thank you very much. Those are my brief comments.
Thank you so much, my lord. We appreciate your very, very, very valuable contributions. We would like to call on Ms. Olaide to give us more insight on the question she was about to answer, which was directed at his worship. Very briefly, ma. Thank you.
Okay, can you hear me? Can you hear me?
Yes, we can hear you. Please go on.
All right. Just for the sake of clarification, I think the question that was asked was that what is the position? Is it that what's the position of the law when there's criminal proceedings against one party? Can you please remind me of the question again? If a parent, I think you said if a parent is facing criminal proceedings. I can't hear you, Ugochi. You're on mute.
Okay, let me read the question.
All right.
She would like to know if where there's a pending criminal case will it be affected, or will it affect the parental responsibility application in the UK, even though the case has not been concluded?
Yeah, it will affect the parental responsibility application, because if you are facing criminal charges, obviously, and you're applying for parental responsibility, which will confer you the opportunity to be able to have direct access with the child. So it's now at the discretion of the court. So my advice, if you're facing criminal proceedings, you most likely the judge is going to want that matter to be concluded before they continue with that family law matter with regards to the contacts of the children. So it all depends on what you are seeking. If you're applying for parental responsibility, yes, that will be granted if you can prove that you are the biological parents. But if you are facing criminal proceedings, I will need to ask more questions. Where is the child? Where is the child located? What's the position of the local authority? Is the child being faced with care? Is there care proceedings? So it's not like a direct answer, yes or no. But on a general basis, if you are being faced with criminal, I don't think that should affect your application for parental responsibility. It's just to say that you can. But however, it could be restricted or refused depending on the circumstance of the case.
Okay, thank you very much. Lastly, we'll be calling on Mr. Kehinde Ayileka for his very insightful contributions.
Okay.
Hello, Mr. Kehinde. Can you unmute yourself, please? Okay, at this point.
Yes. Can you hear me now?
Yes, we can. We can hear you, sir.
Okay, yes. My contribution is I just want to answer one of the questions that was asked in the first place about UK immigration law in relation to child parental abduction. Now, what I want to say is now some people have usually make mistakes thinking that when one parent in the UK wants to bring the other child, that it needs the consent of the other parent in Nigeria. That is not the case. Now, there's only one basis on which one parent in the UK can bring the child who is resident abroad. And that is the parent in the UK must prove that he or she has sole responsibility for the upbringing of the child. So that is the only reason you can bring the child from the UK. So if you go ahead to obtain consent from the other parent, that application will fail. Because by the other parent giving you consent, it shows you do not have sole responsibility. So it's either you are able to prove that you have sole responsibility or you get a court order from Nigeria saying that you have full custody, sole custody, not full custody, that you have sole custody, and so you have sole responsibility. These are the only ways you can prove that you have sole responsibility. If you show that, yes, both parents, if you are able to show that you have full custody, but the other parent in Nigeria still has access to the child, they will not allow you to bring the child to the UK. So I have seen many clients, they go, when they want to bring the child to the UK, yeah, the other parent is happy for the child to come to the UK. And then the parents here, they go and obtain a consent letter from the other parent in Nigeria, and they submit it, and the application is rejected. So if where the other parent is able to give consent, you are proving that you do not have sole responsibility. So consent of the other parent is not required for a parent who has sole responsibility to bring a child to the UK. So if you obtain consent, that application will fail. So that's what I just want to add to it. And then, of course, I think the other one has been answered. Now, there is a question whether if you bring a child to the UK, where the father, if a mom brings a child to the UK, where the father has full custody granted by the court, and the mom brings the child to the UK without the consent of the father, can the child be deported? The question now is, how is the mother able to bring the child to the UK in the first instance? She must have told a lie in the application. Because for the mother to be able to bring the child to the UK, she must have proved or provided evidence, false evidence, that she had sole responsibility, because that is the only basis on which she can bring the child to the UK. So what many of them do is they say, oh, the father of this child is not in her life. I have sole responsibility, nobody else. So on that basis, so the woman will have brought the child to the UK using false materials. Now, whether the child is going to be deported, it's another thing. So it now depends on the circumstances of the child at the time of the consideration of that, at the time of that, the matter came up. Now, if the child has spent a lot of time in the UK, 7 years, and is still under 18, it's going to be difficult to say you want to return the child to Nigeria. So they will, at that time, be considering what is in the best interest of this child. Is it in the best interest of the child to be returned to Nigeria to the father or to the mother, or to remain with the mother? So that is the question that will be answered. So it depends on the way it is answered. What is in the best interest of this child? That will determine what the decision will be. So that's just my contribution.
Okay.
Thank you.
Thank you so much, everyone. I will at this point now hand over to the chair of the Committee of Fundamental Rights, Family Law and Human Rights Committee of the Section on Legal Practice of the NBA, none other than Mrs. Nancy Ubing. You're welcome, ma'am.
Thank you very much, Ugochi, and thank you, everyone. I think I would start by apologizing because we started behind schedule. It wasn't meant to be, but thankfully we've had a good session this afternoon. I believe it's a time well spent. I also bring apologies on behalf of the section chairman, Mrs. Boma Alabi, SAN OON. She's unavoidably absent. She was to give us her opening and welcome remarks. But she's attending the National Summit on Justice in Abuja. And I believe she's that much engaged and she just can't be with us this afternoon. But she sent her goodwill message and she has asked that I read it out. So if you will bear with me in a few seconds, I will just read out. She says, congratulations to the Nigerian Bar Association Section on Legal Practice, Family Law and Human Rights Committee on its inaugural outing following the merger. The merger she's referring to is child's rights and family law and human rights all coming together. To the topic of today's webinar, she says it's been carefully chosen, not least because it straddles the two aspects of family law and human rights. Parental child abduction is sadly common and really not much talked about, hence the need for this very important discussion. Children are being abducted on a local basis daily and frequently also internationally, with the complicity of embassies and other diplomatic missions at an alarming rate. Well, she's looked forward to the insights and outcomes from today's session. Unfortunately, she's not here, but she has also said that what we're doing today, or what we've done today, will progress the search for justice for all and prioritizing the right of the child to both willing parents in the process. Our gratitude and appreciation goes to the distinguished speakers and facilitators. And of course, she's thankful to the committee and the chair, the experts and everyone. So on that note, I would give the vote of thanks for all participants today, starting chiefly with the panelists. Thank you so very much for accepting to be here today, for working hard to put together what you presented today. We know that didn't come easy. It was a lot of work, and we thank you so very much for what you've done today. It's really a time well spent. It's been a learning process for a lot of us. We are sharpening our skills as practitioners in this field. Thank you for sharing from your wealth of experience and your wealth of knowledge. We are indeed very grateful. And of course, I'm also very thankful to the section chairman who has provided a lot of support for what we're able to do today. I thank every participant here, particularly those that have been asking questions and making contributions. We're particularly grateful as a committee that we're able to attract people from the academia, the bench, the bar. Thank you so much for signing in. Thank you, my Lord Honorable Justice Akeredolu, for being here today. I also know there are other members of the bench who are on YouTube, and thank you so very much. And I would like to mention your names if I can see them now. Honorable Justice Thompson, thank you for coming and leaving that comment. It means a lot. Thank you, Honorable Justice Onyika Sola, I didn't mother that name, Oluboyede. Thank you, and thank you, Justice Ajileye as well. Thanks to the learned sales who are here. Thank you so much. I'm not able to identify everyone, but we're really grateful to have you here today. And the members of the lower bench too who are here. I think it was also mentioned that Magistrate Sarah Savo, I hope I haven't murdered the name as well. Thank you for coming and joining us today. And we're looking forward to more insightful times in our next webinar. We would let you know, we have your contact now, we'll send out the message when next we're meeting. And we'll hope you'll also join us there. So we'll continue to share and grow in our knowledge of the law in this area. Thank you so much, the technical team. I know we've had our glitches, but we are here now. So thank you for all you've done. Thank you for everything going on behind the scene. Very grateful. And thank you to the participants. Thank you for staying on this long. We appreciate you. Thank you so much. And finally, I'm just absolutely thankful to God that this has come to take place, and it's all good. We'll continue to improve and do better in our next outing. Thank you all so very much, and God bless. On that note, I believe we are going to have the group photograph for all those who are still on. If the technical team will unmute videos for everyone who is happy to turn on their videos, we'll have a group photograph for the records. Thank you. Technical, are you capturing anything so far, or you still want to wait a while?
Yes, we are, Ma. We're just waiting for a few more people to join. Thank you.
You're giving them the liberty to turn on their cameras.
Yes.
I can think we have a good number now.
Okay. Mm. Okay, and I think that's it now. So there's one more person trying to.
Thank you, ma'am.
Yes. So 1, 2, or let's say 3, 2, 1. Say cheese. Thank you. Thank you very, very much. Thank you, everyone. Thank you.
Okay.